Coming to this, I think it's our third Stanley Civility Seminar sponsored by the St. Joseph County Bar Foundation. On behalf of the Bar Foundation, thank you for coming. We're going to start with Tom and Kelly are going to introduce our panel and our program today. We want to thank Tom and Kelly for doing this for a number of years now. And of course, Amy McGuire, I don't know where she went, for always running these and setting them up. I'm a member of the Board of Governors for the St. Joseph County Bar Foundation. If you don't know, the Bar Foundation is really the philanthropic arm of the Bar Association. We were formed in 2008, and our purpose is we're dedicated to meeting the needs of the public and legal profession through educational programs, legal services, and civic projects offered within the local community. And our mission is to increase public awareness of the law and the legal system, facilitate educational opportunities related to the study of law, and improve the justice system and the legal profession through our supported grants, programs, and projects. A lot of you know us for the high school mock trial, or for the Civility Seminar, or for example, Judge Manier has had book clubs and things like that. What I want to do is remind you, all of these programs were grassroots. They came from ideas that members of the bar had. As a Board of Governors, we look for that. We don't come up with the ideas ourselves. So if you have ideas that meet these missions, please let us know, because that's what we're here for. Having said that, Tom, you and Kelly can take it away.
Okay. Thank you, Joe. Again, welcome again, or welcome back, or if you're a first-timer here, welcome to the third biannual William Stanley Seminar. We did this in 2016, shortly after Bill's death. Back in 18, COVID kind of interrupted our program in 2020, so this is our third biannual. We alternate this with our local practice seminar. So local practice seminar 1 year, Stanley Seminar the following year. If you haven't turned your cell phones off, please do that. Put them on silence. Some of you are new here, and I want to give you just a little historical background on how the seminar came about. Bill Stanley was the example of not only a competent lawyer, but a lawyer that did it in the right way. Did it exuding professionalism and civility, which were respected by the judges, by his fellow lawyers, and by the community as a whole. Bill died in 2015 unexpectedly of pancreatic cancer. Shortly after that, Bill being a great friend of mine, I met with Mary Jane and their 3 boys and suggested that I wanted to put together a seminar that would honor Bill and memorialize Bill over a long period of time. And I asked their permission to go out and try and raise some money to do that. And my goal at that time was to raise about $15,000 so that we could carry this program on for about 10 years, every other year, being the time that we do the seminar. And we were fortunate enough to raise $53,000. So this program is going to go on for a long time. And that's an honor. That's because of Bill and who Bill was. I reached out to the business community. I reached out to lawyers. I reached out to law firms. Everybody said yes in a big way. Some of you don't know Bill, or didn't know Bill. I want to read to you what Judge Miller wrote when we reached out back in 2016 and asked people who knew Bill very well, what kind of guy was he? How would you describe him? And here's what Judge Miller wrote. Bill represented the best of our profession. He cared about his clients and worked to help them achieve not only the best legal, but also their best personal outcome. He treated his clients, the court, and his fellow counsel with courtesy and respect. He embodied professional integrity. His word was his bond. That was Bill Stanley. And I would charge each of us with trying to meet that standard in our practices, trying to do what Bill did and did so well. We have several judges here today, some still active, some retired. I'd ask them to stand and be recognized, and magistrates as well, please. Also up here, not standing, is Judge Bob Miller, I'll say retired, but really senior judge in the Federal District Court, and his spouse, Jane Miller, retired from the St. Joseph Superior Court bench. On behalf of the bar and the foundation, thank you for the service all of you render to our community day in, day out, and to the profession as a whole. We also, as part of our seminar, invite newly admitted lawyers to attend this seminar as our guests at no cost. And I think we have a few new lawyers here. Anybody fall within that category within this time, the last 4 years, since COVID interrupted the last session? New lawyers? One back here. Thank you for attending. Welcome to the bar. Congratulations. I also want to thank the History Museum. This is the 3rd year that they have allowed us the use of this space and the space out front for our reception at no cost. And that's very, very generous on their part. I want to thank Amy McGuire, the Executive Director of the Bar Association, and the bar in assisting the foundation in putting on this seminar. And finally, I want to recognize a very important lady, and that's Mary Jane Stanley and her son, Brian. Mary Jane, where are you at? Brian happens to be married to my co-moderator, Kelly Stanley. Okay? So there is a connection with the last names. The Stanleys had 3 kids, 3 boys, all Notre Dame grads. Michael's in Chicago. Is Kevin still in Chicago? Yes. Kevin, and Brian's here in town. So with that, I'm going to turn it over to Kelly, and please enjoy.
Thank you so much, everyone, for coming. On behalf of the Stanley family, my mother-in-law, Mary Jane, my husband, Brian, and Michael and Kevin, we welcome you here. I feel so fortunate to be able to do this. Although none of his sons became attorneys, I became the attorney in the Stanley family with Bill. So that was always a wonderful treat for me. He and I could talk shop. And I met Brian early in law school, and Bill became such a wonderful mentor for me. So on behalf of all of us, welcome. On that note, we've talked about how we would like to increase the participation of younger attorneys at this seminar eventually. But perhaps today opens up the discussion of mentorship for all of us to assist in young lawyers in being a mentor. And we talked about this a little bit a couple of years ago, but I think it's more important than ever as our community, as just the general divisiveness that we see in politics and international relations. I think more now than ever, it's important to remind young attorneys of how important it is civility, keeping professionalism in the practice. I myself am fortunate enough to work as an adjunct professor in the deposition skills program at Notre Dame. So I get to see firsthand some of the young lawyers and what they're thinking about, prepare them for depositions, which is arguably probably one of the most difficult portions of practice to keep civility in, right? And they ask, what do you see out there? Tell us your funniest stories. And I'm like, well, they're not all that funny because it shouldn't be happening. And I reiterate to them over and over in class, you can be effective and still be civil to your opponent, to your clients, to your opponent's clients, and how important that is in our practice, right? So perhaps today can open the discussion of how we bring in younger attorneys and how we can each mentor them to keep the civility in our profession. With that, I would like to introduce our distinguished panelists, who I am so excited are here. I think our panelists were a bit frustrated with our intentionally vague instructions on their speeches today, or their presentations, but we have such a diverse panel of perspectives. We have 2 judges. We have Dean Cole from the law school, and then we have 2 practitioners, one of whom has focused more on defense and one more on plaintiffs. So we intentionally kept this vague so that we could get the various perspectives. I'm going to go through this. I did have to cut out some of the bios because they were very long and I didn't want all of us to feel bad about not doing enough with our lives after reading some of these. So with that, we have the Honorable Robert Miller Jr. He is a U.S. District Judge for the Northern District of Indiana, now senior status. He was appointed in 1985. In total, he serves 37 years on the bench. He is a chair of the Seventh Circuit Panel Civil Jury Instructions Committee from 2002 to present. He attended Indiana University School of Law. He authored the Courtroom Handbook on Indiana Evidence, Indiana Evidence, the 3rd edition, Indiana Evidence, the 2nd edition. So he wrote the book on evidence and all of the updates. We also have Dean G. Marcus Cole. He is the Joseph A. Mattson Dean and Professor of Law at Notre Dame Law School. He was appointed by President Reverend Jenkins in 2019 and is the 11th Dean in the history of the Notre Dame Law School. Dean Cole is a leading scholar on the empirical law and economics of commerce and finance. He was a faculty member at Stanford Law School from 1997 until he came to Notre Dame. At Stanford, he held 2 endowed chairs and taught courses in the areas of bankruptcy, banking, contracts, and venture capital. He also served 5 years as an associate dean for curriculum and academic affairs. Before joining Stanford, he was an associate with the Chicago law firm of Mayer Brown. He clerked for Judge Morris Shepard Arnold of the U.S. Court of Appeals for the 8th District. And he earned his bachelor's degree from Cornell and his Juris Doctorate from Northwestern University, where he served as editor-in-chief on the Northwestern Journal of International Law and Business. Yes, very impressive. Thank you for coming. Equally as impressive, we have Alice Springer, who recently joined Patrick Industries as in-house counsel, senior counsel. Prior to joining Patrick, Alice spent 15 years at Barnes & Thornburg, where she was a partner in the litigation department in South Bend. As a trial lawyer, Alice's practice focused on products liability and mass tort litigation, as well as general commercial litigation matters. She participated in state and federal trials and led the discovery team responsible for discovery for 18 retailer defenders in the MDL preceding Zantac products liability litigation. She was a key member of the discovery team for the retailer defendants in the asbestos talc and ovarian talc litigations. She also assisted with in various capacities with opiate litigation. Before joining Barnes & Thornburg, Alice was a law clerk for the Honorable Christopher Nectarline at the United States Magistrate Judge. She currently lives in Middlebury with her husband Doug and their 3 children. We also have Doug Sagaguchi, who is a partner at Piper, Morgan & Stasiak, where he focuses on helping personal injury clients, and he's been there since 2000. After obtaining his undergraduate degree from IU Bloomington, he obtained his law degree from Valparaiso, where he served as law review editor. His prior seminar presentations include a wide range of topics, including litigation best practices, uninsured and underinsured motorist coverage, lien resolution, deposition practice, and procedure. He enjoyed serving the legal community as the president of the St. Joe Bar Association. He was a former member of the St. Joe County Bar Association Foundation, former secretary of the Robert A. Grant Inn of Court, and his memberships include the Indiana Trial Lawyers Association, American Association for Justice, the Indiana State Bar Association, National Trial Lawyers, the Indiana Top 100. He provided some, in his personal time, he also enjoys outdoor activities, snow skiing, water skiing, and backpacking. And finally, we have the Honorable Jane Miller. She earned her law degree from Valparaiso University and spent 10 years in private practice. Did I get that wrong?
I graduated from Notre Dame.
From Notre Dame. I blame South Bend Tribune for that because So thank you for that correction. She earned her law degree from the University of Notre Dame. She spent 10 years. If anything else is wrong, please blame the South Bend Tribune.
I know most of the people in the room I will correct today.
Okay, thank you. 10 years in private practice, prosecuting child molesters and handling probate cases. Now I'm nervous for all of this to be incorrect. She retired in 2021 after more than 14 years presiding over criminal cases in the St. Joseph County Superior Court. She was a dear friend of my father-in-law. She spoke at his funeral, and he spoke with such respect for her. Brian's the emotional one, not me. Before I even lived in town, and she paved the way for a lot of the judges female judges that we currently see in this area in St. Joseph County. So all due respect to the Honorable Jane Miller, and thank you for speaking. She now keeps close tabs on her 2 grandchildren, young grandchildren, and it's a treasure hearing about them. And I'm sure Judge Robert Miller also keeps close tabs on those grandchildren as well. So that is our panel today. I'm excited to hear them speak. We will get some various perspectives on civility in the practice of law today. And with that, I will introduce the Honorable Robert Miller.
Thank you, Kelly. It is a thrill for me as well as an honor to be able to speak at an event that honors Bill Stanley. Bill was a terrific lawyer, an even better person, and a good guy to play golf with. My courtroom misses his professionalism and his civility, and I miss his friendship and his positivity. So the topic for all of today's speakers, the topic of the workshop is civility, and that's a big topic. I'm going to talk about what I know, which is civility between lawyers and from the judge's viewpoint. And I'm going to focus on just one aspect of that. Nearly 30 years ago, the United States Court of Appeals for the Seventh Circuit appointed an ad hoc committee to develop civility standards for the courts of the Seventh Circuit. It's posted on their website and posted on my court's website. And I urge you to look at it. It's called the Standards for Professional Conduct within the Seventh Circuit. If you were admitted to either the Northern or Southern District since 1993, you had to certify that you read those. And I would urge you to read them again and to tell other lawyers to read them, because it's what federal judges expect in the way of civility, and I've never seen a better presentation of those expectations. And I have no reason to think that state judges expect anything different. What I want to do today is to talk about Standard 4 in those standards under the section Lawyers' Duties to Other Counsel. Because this is the one I see problems with most, and I've gotten to the point where it really bothers me. It reads, "We will not, absent good cause, attribute bad motives or improper conduct to other counsel, or bring the profession into disrepute by unfounded accusations of impropriety." This leads me to the first point that I want to raise as far as why you should aspire to civility. And the first reason is that not to do so hurts your client. And I will offer a confession to make this point. Judges and law clerks see all sorts of stuff in briefs. That doesn't help us decide the issues before us. Sometimes it's innocuous, but sometimes what you see doesn't challenge the other side's argument as much as it challenges the other side's attorney. Sometimes it purports to reveal the mental operations of opposing counsel. The plaintiff is trying to pull the wool over the court's eyes, or the defendant is trying to distract the court from the main issue, or my favorite, what the other party really is trying to do is to, by this motion, what he's really trying to accomplish is, here insert. And sometimes it's hidden a little, like when I read in a brief that the other side is making an argument disingenuously. I looked that up this week on thesaurus.com. The first 4 definitions for disingenuous are deceitful, dishonest, false, and unfair. Substitute those words for disingenuous in the brief, and if it's not really an accusation of unethical behavior, it's a pretty close cousin. Well, we who read these briefs for a living see, in addition to those, ad hominem attacks, over-the-top sarcasm, everything but accusations of the sorts of ancient torts we all learned about in ethics, our ethics classes in law school. The stuff isn't just unproductive, it's unpleasant to read. I get sick of reading it. I don't want to read any more of it, and so I don't. I skip that paragraph. And sometimes if it's been going on for a little while in the brief, I'll skip from the middle of page 14 to page 16, just because I don't think I have to read all that stuff. So if you have ever included an attack on your opposing counsel and embedded it, some legitimate argument within it, I'm sure I'm sorry, but I didn't read it. And doing something that causes the judge to not read your brief strikes me as within any definition of poor advocacy. I'm sure that if I read all the emails that led up to that brief, I would better understand why the attorney felt the need to include all that stuff. But if being able to express those thoughts is what kept you motivated to write your brief, go back through it and take it all out before you file it. And while you're at it, take out the adverbs. Adverbs can make people angry, but never persuade anybody. Now, I suspected that other judges handle the personal attacks in briefs the same way I do, so I asked some of them. And it's surprising how few judges will admit to skipping portions of briefs. One judge told me that when he gets to the personal commentary, he clicks a mental fast-forward button, which I thought was a pretty good metaphor. None of the judges that I talked to said that this sort of personal attack makes them any more inclined to rule in favor of the brief writer. That's not the only way uncivil lawyers harm their clients. Judges have an enormous amount of discretion, and judges are human. And one article that I read in preparing for this had what I thought was a wonderful quote: "Judges are just lawyers with whistles." And judges also have long memories. You know, when I would look at my calendar, I know this is true of other judges, and see that Bill had a case on that calendar, we smiled, not just because he was likable and friendly, but also because we knew he would present his case well without attacking the lawyer on the other side. There are other lawyers who, when noticed on the day's calendar, get an eye roll instead of a smile. And every time that lawyer comes into court and acts rudely or unprofessionally toward the other lawyer or toward the court, one of his clients pays. Maybe not the client with him that day. There'd be a lot of discretion involved in what's going on that day. But some client with him someday will lose a discretionary ruling in which the judge's unconscious, perhaps, distaste for that lawyer's tactics played a part. A second reason to be civil, a second reason to be civil is that incivility harms our profession. I had a criminal jury trial earlier this year. And trials are just starting to make a comeback, jury trials. It was my first, among my first in quite a while. I had really good lawyers on both sides. They beautifully conducted examinations, well argued. One of the casualties when we're not doing jury trials is that the public doesn't see what we do. When people see and understand just what it is that judges and courts and lawyers do, their esteem for us rises. We're viewed better. And I was so pleased that these jurors were seeing an excellent trial. But then we got to the final arguments. The defense attorney's rhetoric evolved as he proceeded from start to finish, and what started as, they didn't present this evidence, so we put it in, turned into, here's another thing that they didn't tell you. And eventually the inevitable, here's another thing they didn't want you to know. And that last comment actually related to a defense exhibit that came in without objection. So they were not only dastardly prosecutors, they were ineffective, keeping the jury from knowing it. But by the end of the argument, it really seemed as though the defendant had been the victim of a vast conspiracy that involved the victims, the investigators, and the prosecuting attorneys. The government's rebuttal was delivered by an obviously angry United States attorney who began with something like, well, I'm offended but not surprised, given all the things he lied to the victim about. And in that one sentence, what the lawyer did was to turn the defense attorney into the alter ego of the defendant himself. The lawyers were no longer just advocates, they were participants. One side had conspirators to falsely convict, and the other side had a fraudster. Now, I've heard worse in final arguments, and I'm sure you have, and I know I see some of the judges from the criminal division in Superior Court who have heard similar things. But if you go back to that Seventh Circuit standard that I read to you before, we will not, absent good cause, attribute bad motives or improper conduct to other counsel or bring the profession into disrepute by unfounded accusations of impropriety. I've got enormous respect for the lawyers who tried the case. They're among the best lawyers that have appeared in front of me, quite professional, but I can't quite square those final arguments with that Seventh Circuit standard. And it does harm the profession. My court asked jurors to fill out questionnaires when our trial was over. Maybe a dozen things like, how was the parking, how were the snacks, how did we treat you, and then sort of an essay question at the end. How can the jury experience be improved? And one of the jurors from this case wrote something, he checked excellent to all of the simple questions, and then when he got to the essay question, he said something like, have the lawyers talk about things that will help the jurors, not just perform like they were on TV. So we had this juror who was seeing us at our best, the profession at its best, and he or she left the courtroom with that thought in mind. I've been talking about civility between attorneys. I don't want to be understood as suggesting that there isn't a problem with judges being uncivil. Rude is often a better word to lawyers or their clients. Civility within the profession suffers when judges belittle an argument or a litigant or even judicial colleagues. I will tell you, I've been attending state and federal programs, judicial education programs, for almost 47 years. And I think that I might have gone to a lecture in 1979 on judicial demeanor. And all the other ones I've gone to have no such time. And so maybe that's a place that we could start. Or you might have seen in the speech just last week that Judge Stefanos Gibas of the Third Circuit Court of Appeals urged colleagues to write fewer look-at-me opinions, as he put it, that play so well on Twitter. And maybe that can start a needed discussion among judges. Finally, Kelly asked us to offer suggestions on how to deal with incivility. I know we've got at least one person admitted last week. No? Were you the new attorney over here? Were you admitted last week? No. Okay. I was going to say, anybody admitted last week probably hasn't run into it yet. But everybody else in this room has. Litigation is competitive. And human beings try to get an advantage, a dominant position, when competing. And some lawyers are like the people you see on social media who think incivility gives you that advantage. And you will run across the uncivil lawyer. Know it will happen. Know that it's even more likely to happen if you're a newer lawyer or a younger lawyer, the untested lawyer. And it amazes me that I have to say this in the year 2022, but it's even more likely if you're a female lawyer or a person of color. When it happens, don't be surprised by the fact of the incivility, even if you're surprised by the specific form of the incivility. Don't fight back with incivility. You'll feel bad about that later, and it'll hurt any eventual chances you might have for sanctions. But don't think of yourself as simply taking it or turning the other cheek. Think of it as standing your ground. The uncivil lawyer is like the defender in basketball trying to push you off the spot you're supposed to be for the offense. Stand your ground and believe that the judge will see what's going on. The judge is a human being with a long memory without you having to resort to your own incivility. This may not help, but I ran across this story while preparing, and it seemed like it's a good example of how to deal with some of the problems. A judge was sentencing a defendant who just suddenly went off. This guy started shouting the judge was a Nazi or a socialist and a son of a this and a mother of that, and that the judge had bought his law degree off the internet and was a political hack, and on and on and on. Once the defendant finally fizzled out, the judge looked right at the defendant and said, well, that was a lucky guess. Thanks again for inviting me. I really appreciate it.
Thank you, Judge Miller. I'm just going to right the podium and it's getting nervous there. And introduce Dean Cole, please.
Thank you, Kelly, for inviting me to give this talk. When Kelly didn't tell me how long we were supposed to speak, as a law professor, I simply prepared an hour and 45 minutes. I'm gonna try to race through that in a timely fashion. As Kelly mentioned when she was giving my introduction, I taught at Stanford for 22 years, and I loved living in California. I loved Stanford, but I grew up loving Notre Dame. My older brother went to Notre Dame. I wanted to come to Notre Dame, and I didn't get in. And so when this opportunity to become the dean at Notre Dame arose, I jumped at the chance. But what I learned in the 3.5 years that I've been dean at Notre Dame about the difference between Notre Dame and Stanford is something that I didn't expect, but I think is very helpful as we consider civility in the legal profession. And so what I want to talk about today is the value of a values-based law school education in promoting civility in the age of polarization and cancel culture. Now, I think we've all witnessed the near riots and actual riots that break out on college campuses today when speakers have been invited by student groups or educators, and some of those riots have resulted in both bodily injury and property damage. The sad truth is that they've become too numerous and too commonplace to count. It's so commonplace, in fact, that we've developed a name for it, namely cancel culture. Cancel culture has run amok on our college campuses, turning places that were once bastions for spirited and respectful debate and the exchange of opposing ideas and concepts into repressive gulags where only groupthink and conformity are deemed acceptable. Cancel culture has turned even the most elite colleges and universities into little more than credential mills where students hope to escape with a diploma if they're able to keep their thoughts to themselves and their heads down for 4 years. And what's perhaps most disturbing, I think, is that what was once dismissible as the rude and uncivil behavior of poorly raised children has spilled over into graduate and professional schools. We've seen speakers at some of America's most elite law schools shouted down before they could begin speaking, or before their audiences could have an opportunity to hear what they might have to say. We've seen invitations withdrawn before events could even take place. And we've seen disrespectful and even violent protests break out before a controversial word might have been uttered. We've seen law students at one of America's most prestigious law schools protest a law professor for representing a convicted Hollywood sex offender, Harvey Weinstein. And although the professor was able to retain his faculty position, the university in question removed him from a residential staff appointment in an effort to placate the protesting students for a lawyer doing his job. In 2019, at another elite law school, we saw the United States Acting Director of Homeland Security, who was scheduled to give a keynote address on immigration law, shouted down by student protesters before he could even begin his speech. His speech had to be canceled. And this was the interim, or acting director of Homeland Security. Just this year, we've seen student-edited law journals force the withdrawal of invited articles by professors whose conclusions they deem to be unacceptable. To their credit, many legal academics across the country and across the political and ideological spectrum decried this outrageous attack on academic freedom, and many of these academics themselves withdrew their articles from the law review in question in solidarity with the professors who were deemed unacceptable. We also saw the suspension of an academic program administrator for tweeting an unpopular opinion about the then undetermined potential nominee for the seat of retiring Supreme Court Justice Stephen Breyer. And when students at the school learned of the tweet, they erupted in a firestorm of protest, resulting in a 4-month suspension and investigation of the offending administrator. And while the suspension was eventually lifted and the administrator cleared after classes ended, he resigned his position nevertheless. The message from the university to its students was clear. You have the power to silence those with whom you disagree, and disagreeable ideas will be met with force. More recently, the dean of another top 10 law school asked his university to impose a major sanction, including suspension or withdrawal of tenure of a tenured law professor for expressing unacceptable views. And just last month, United States Supreme Court Justice Clarence Thomas announced that he will not be teaching students at George Washington University, something he had done for 17 years after the students at the school protested his teaching there. To be clear, I'm not defending any particular views or viewpoint, especially racist, sexist, homophobic, or other expressions of hate. How could I? I'm an African-American man, and I could be the target of such hate speech. I'm not defending that kind of speech, but that's not what's at issue. What's at issue is that those with legitimate and unpopular thoughts or ideas are being targeted and silenced. And to me, what is most shocking about these incidents is that they're taking place in law schools, of all places. If there's any place where we ought to be training students to challenge opposing ideas with other, better ideas, it's law school. Students are supposed to be learning how to argue not just on behalf of the causes and clients that they believe in, but also on behalf of those that they do not. In fact, we do this all the time in the court, right? We have students argue cases on brief and off brief. How else can students and lawyers learn the strengths and weaknesses of both sides of any issue? Well, what do I think Notre Dame adds to this discussion? This might sound like an advertisement for Notre Dame, and I'm okay with that. I'm happy to report that the kind of things that we've seen in the headlines are not happening at Notre Dame Law School, and it's my sincere hope that they never will. It could be that there's something special or fundamentally different about the students we choose at Notre Dame Law School, but I would like to think that it's something special about Notre Dame Law School that chooses students to want to study law at Notre Dame. And it's not as though things could not have turned out the way this way at Notre Dame as they have at other schools. Upon my arrival at Notre Dame in the fall of 2019, I quickly learned that we had 2 high-profile events scheduled within 2 weeks of each other. The first was a panel on bipartisanship in Washington, D.C. with Senators Chris Coons of Delaware, Jeff Flake of Arizona, and Joe Donnelly of Indiana. And I received hate mail regarding this event. Things like, how could you provide a platform to enemies of President Trump? Since when has Notre Dame become a campaign stunt for the Democrats? And then, exactly 2 weeks later, I got even more hate mail on the eve of a speech to be given by the Attorney General of the United States, William Barr. And that hate mail and protest became so overflowing that I decided to issue a statement articulating our policy on free speech. And it read, the Attorney General of the United States will be speaking here at Notre Dame Law School this Friday, and there appears to be a need to clarify the policy regarding speakers at the law school. From time to time, speakers will be invited to the law school. Faculty, student groups, or other organizations within the University of Notre Dame may have invited them to speak at the law school. Sometimes those speakers are government officials responsible for controversial policies, and sometimes they are people who are known to espouse controversial points of view. As long as they are here at Notre Dame Law School, they are free to say whatever is on their mind within the bounds of the law. Freedom of speech matters. As Frederick Douglass once said, to suppress free speech is a double wrong because it violates the rights of the hearer as well as the speaker. And just as speakers are free to speak, protesters are free to protest. They must do so in a place and manner that respects the rights of speakers to speak and listeners to listen, and that is consistent with the educational mission of the law school. An institution of higher education must be a place where controversial ideas and points of view are expressed, heard, and discussed, and Notre Dame Law School is just such a place. And I'm happy to report that after that statement, we held the event. Attorney General Barr gave a speech without incident. We've had other controversial speakers at Notre Dame since then, but the one thing that I've learned about Notre Dame is that when we do have controversial speakers, we've been able to maintain some level of civility and discourse at Notre Dame Law School when it seems impossible on other campuses. Now, I can't tell you that I know scientifically why this happens, but I have a theory and I have a belief as to why this happens. I think it happens because we are a faith-based law school that actually believes in our core Catholic mission. Now, that doesn't mean that we're all Catholic or that, in fact, that we all adhere to a particular doctrine or dogma. No. In fact, we are one of the most religiously diverse communities in higher education. Our students come from all faiths, and many come from no faith at all. They come from all across the United States. In fact, we're the most national law school as far as our student body is concerned. They come from rural and urban environments. They come from rich and poor communities and families. What they all have in common is that they have chosen to study at a law school that adheres to this Catholic mission, and Catholic with both a big and a small C. On the first day of school each fall, I give a welcome address to the incoming students, and I tell them what it means to be a Notre Dame lawyer, what we call a different kind of lawyer. I give them examples of Notre Dame graduates from the past and how they dedicated their lives to make a difference for others. I then tell them that what makes a Notre Dame lawyer a different kind of lawyer is that whatever they do, whether it's public interest law or corporate law, transactional work or trial work, they are dedicated to serving others in a way that lets others experience the loving, creative power of God in their lives. And I also tell them that this education is not for them. This education is for those individuals and communities that they are going out into the world to serve. And accordingly, the people that they are going out into the world cannot be bothered with whether they happen to be offended by something someone else says, whether it's a classmate, an instructor, or an invited speaker. Their future clients have real problems: job loss, discrimination, racism, plant closings, bankruptcies. They can't care whether you're offended by something. Furthermore, because they have real problems, you can't wait until you're out in the real world to confront the problems that they must confront: racist ideas, discrimination, crimes, vulgarities of every type. There are no trigger warnings in the practice of law. You must face the ugly things of this world because those whom you're called to serve will have to face them. And I tell them that ideas, including offensive and unpleasant ideas, are what we deal with as lawyers. A law student who is afraid of ideas is like a medical student who is afraid of the sight of blood. Finally, I tell them that the hallmark of a Notre Dame lawyer is to treat others with dignity and respect, even if you disagree vehemently or are offended by what they have to say. I tell them to look at each other. And when you look at each other, recognize that you are looking at a person, whether you agree with them or not, you are looking at a person who is created in the image and likeness of God. And you are to treat them that way, whether you agree with them or not. And ultimately what I think happens is that our students learn that, the practice of law is about treating others with dignity and respect and about service to others. And I want to conclude by saying that I tell them that whether they believe in God or not, or whether they're Catholic or not, whatever their faith background, that we need to look to Matthew 25 to determine what the way we should live our lives, where Jesus said, when I was hungry, you gave me to eat. When I was thirsty, you gave me to drink. When I was naked, you clothed me. When I was an immigrant, you welcomed me. When I was in prison, you visited me. Well done, good and faithful servant. Now enter into the home of my Father. And I tell them, whether you're Catholic or Christian or Jewish or Muslim, all Notre Dame lawyers at the end of the day ought to think of themselves as Matthew 25 lawyers. It's our purpose to go out into the world and serve others to make the world a better place. And with that, I thank you for this opportunity. Thanks.
Thank you everyone for the Stanley family for allowing me to be here this afternoon. As Kelly mentioned in her opening remarks about me, I used to clerk for Magistrate Judge Nectarline when I was straight out of law school. And one of the first things I remember about going to work for Judge Nectarline was how the staff there interacted with attorneys. And Judge Nectarline had a fabulous courtroom deputy that whenever Mr. Stanley would call, you could always hear through the wall say, "Mr. Stanley, how are you today?" And let me tell you, that reaction was not given out to every attorney that called chambers. And so I learned very on that your reputation as an attorney can be gauged by what the courtroom staff, how they interact with you, and what they feel about you. And that was one of the things that I took away, is trying to, walk away saying, I want to be one of those attorneys that when I call chambers, they are excited. They're like, "Mrs. Springer, it's nice to talk to you today." And I think that's one thing that we all should try to strive and follow the example that Mr. Stanley has set for all of us. When I was asked to speak today, it was difficult to think, what should I speak about? Because there are so many things that you could discuss. And being in private practice and litigation for 15 years, we all have our war stories about the horrible things that we've seen and come across as litigators. And I think we could all stand up here and talk about the experiences we've had in depositions. For example, I've been in one of those depositions even recently when we were trying to move to the Zoom platform, and there was an aggressive attorney badgering a witness, and a very skillful, seasoned woman attorney on the other side was trying to lodge her objections. And the gentleman during the deposition on the record said, "Don't be so emotional." That there's no place for those types of comments in a deposition, in litigation, and especially when it's something as derogatory towards another woman attorney. You don't need to say, "Don't be so emotional" during a deposition. But I think the tone of litigation starts even before those interactions and depositions. And one of the things that I see that sets the tone frequently is even written discovery. And you may think, how can written discovery set the tone for civility in litigation? But I think it really does. Think about how many times each of you have received a set of discovery requests that ask for all documents or everything under the sun. That written discovery sets the tone for how you're going to respond. Are you going to respond back with 15 pages of boilerplate objections that then sets off a series of meet and confer letters, which then escalates the situation? Or are you going to respond back in writing and say, "I object, this is overbroad, but I will go ahead and provide you these documents," which I think are the documents that you're really looking for. And even though that's not a verbal communication, we're talking about civility, you tend to think civility in terms of verbal. I think those written communications are just as important as the verbal interactions and face-to-face interactions, because that really sets the tone for litigation. What's equally as frustrating is when someone sends you a pound sand letter. I don't know any time when a pound sand letter has actually achieved its objective. Most often when you call someone, they're not even willing to back up the positions that they've put forth in that letter. So when you're talking to someone, if you're not willing to back up the positions when you're having a conversation over the phone or worse in court, then why put them in a letter and set that tone? Because you're just going to put everyone on the defensive to begin with. I could go on and on about all of the things that I've seen as far as discovery, but I thought, we have so many of these civility discussions about what it means to be nice to one another that I kind of wanted to think about what are some aspects of civility that don't get talked about as often. And one of those things I thought about addressing was the perceptions of attorneys before you even meet them. I've noticed in our community and in other communities as well that we sometimes have perception of a lawyer and how we want to litigate the case simply by where the lawyer works. We have preconceived notions of this person works for such and such firm and all of those attorneys there think they're better than everybody else, or they litigate things and want to, bury you in paperwork. And so you go into those cases already thinking ahead of time, I've got to be more aggressive with this attorney. Conversely, you have those people that may incorrectly assume this person doesn't have as many resources available. So I can bury them in paperwork, and they're not going to be able to handle all of the paperwork that I send on them, serve on them. I think that's an aspect of civility we really need to think about, or what are our implicit biases towards people just based on our perceptions. You may have had a bad experience with an attorney from the firm. Are you then imputing that to all of the attorneys in that firm and thinking, oh, they're all like this? And I think you just really have to think of each time you engage with a new lawyer from another firm, thinking about who is this person, how am I going to litigate, but not lose fact of you're not litigating this case against this specific person or this specific firm. It's the clients. You have to keep focused on the clients and what's in the client's best interest. My husband is a high school basketball coach. And you see these coaches out there a lot of times where at some point they are in it for the win. And they lose sight of why they're doing it. They're in it because they want to say, I boast a 200-win record, or I'm a state championship coach. But at the end of the day, they lose sight of they're there for the kids and they're there for coaching. And unfortunately, I think sometimes as lawyers, we get caught up in the thrill of the competition and the thrill of the victory. And we forget it's not about us. It's about the clients. It's about serving them. We are in a service industry, and we always have to put our clients' needs above our own desire to win and to beat someone. The other thing that I want to address is communications. I think email is great, and I also think email is horrible. I think so many times it's so easy when you get an email that makes you upset to fire off a response within 5 minutes of receiving an email. That's normally not the best case because you're going to say something that you regret, something that you can't take back, and inevitably something that will appear as an exhibit to a court filing. Pick up the phone. We've lost contact with people, especially with the pandemic. I think, just being able to talk to people face to face over the phone to resolve differences is really a skill that we're losing. And we need to be able to have that communication because there's so much more that can be resolved when you talk to someone over the phone than when you exchange 10 or 15 emails. A prime example of this was the case that I had just this summer where 2 attorneys in Texas were fighting over a request for a deposition and document request to accompany that deposition. It resulted in 3 weeks of back and forth correspondence, a motion to compel in front of a Texas state court judge. It was elevated to me. I finally took a look at it, knew the other attorney on the other side, picked up the phone. I said, Michael, we've worked on this case for 1.5 years in the MDL. What is it that you're wanting in this one-off case? He goes, I'm just wanting the same stuff I got in the MDL. I'm like, done. 5-minute phone conversation that we could have saved 3 weeks of time and a motion to compel. That if the 2 other attorneys working the case had just picked up the phone, could have been resolved. And so again, just thinking about communicating and how you communicate and communicate effectively. The other thing I think that we lose sometimes as well when we're talking about civility is not only how we are treating and talking to other attorneys, but how are we treating those that we work with internally with our own firms or our own chambers. I think we are so focused on all of the deadlines and making sure things are filed correctly. Mistakes are made. And I'm so tired of seeing people that say, my secretary filed this wrong, or my paralegal didn't do this, or my associate messed up. We are a team, and as the partner in charge of the case, you need to take ownership. And it's not I, we, and blame. It's a team. Let's fix the mistake. Let's do it together. And what that builds is trust within your team. And I think it builds a camaraderie with your team, and it creates a better work atmosphere. There are young attorneys always watching you, no matter what you do. And I think it's very important within your own law firms and within your own chambers to make sure you're showing them what it means to be a team player and that we're in this together for the client's interest. I think the other key part of that is appreciation. Appreciation goes a long way when you're talking about civility. Working in a private law firm is very stressful. especially if you're on a big litigation where it's about the company type litigation, or even somebody's small business is at stake. There's a lot of pressure and you can succumb to the pressure. But just telling people thank you goes a long way. One of my mentors, Tim Abaska, I worked really hard for him before he retired, and I would do anything for him. I would do anything for him and work as hard as he needed me to work because he always said thank you. And he always said, you're a valued member of my team. My practice wouldn't be the same without you. And as Kelly's talking about mentorship and what can we do as mentor and to increase mentorship, I think it's important that we look in our own firms and our own offices or our own companies first and say, who can I mentor? Who can I be that person for? And just showing that appreciation and gratitude for what they are doing. In turn, I think that appreciation and gratitude will rub off because then they will be in a better mood, so then they may go and interact better with someone else on the outside. Because you never know when the interaction that you have with someone will affect them and they will pass that on and carry it on as well. Another example of this when we're thinking about what can we do. A dear friend of mine who is no longer with Barnes & Thornburg, but I had the honor of doing a 3-week trial in Delaware with him. It was a very stressful time. We, came away from our trial with a successful judgment. But at the end of the trial, I can't tell you to this day what witnesses we called or what the number we ended up with. What I remember is when we got back to South Bend about 2:30 in the morning, as he got into his car, he handed me a thank you note. And the thank you note said, I couldn't have done this without you. You're a valued member of my team. Thank you for all of your effort. And what I've taken away from both Mr. Abaska and from this other individual who's now gone on to better things is that I want to be like them. And I try to implement those acts of kindness and how they showed me respect and appreciation to those that I work with. And to know not only those that I work with within my firm, within my company, but also those that may be my adversaries. And in closing, I just want to leave you with a quote. This is from Todd Gonwer, who wrote the book, Lead for God's Sake. Every word, attitude, behavior you choose has the potential to influence someone else's words, attitude, or behavior. Choose wisely.
Thanks, Kelly. I knew you were going to introduce me. I just jumped up anyways.
I was just riding the podium.
Thank you. If it starts to fall, please catch it. Good afternoon, everyone. It's a true pleasure to be here. I love this auditorium. It's a real gem in downtown South Bend. It's always nice to be here, and we're lucky to have it. Thanks to the Bar Foundation for allowing me to speak. It's a privilege to share the stage with all of these great speakers here, and especially to do it in Bill Stanley's honor and his memory. It's easy to come up here and do this for someone who would appreciate, I'm not sure he would appreciate the spotlight on him, but he would appreciate the subject that we're all talking about, the fact that we are continuing conversations like this and making sure that civility and professionalism is part of our everyday lives in our work. I think a little bit of this situation is preaching to the choir, because I look out and I see some outstanding lawyers, very professional lawyers, very civil, people that I've worked with, people that I practice in front of, judges, etc., very professional and very civil people. I'm guessing 90% of you came here because you are interested in this topic and think that it should be discussed and talked and promoted, and the rest of you probably not so much. So if you guys could please stand, I would so I know who to talk to, I would appreciate that. Honestly, the truth of the matter is that this is something that we all need to talk about, that we all need to realize, that we all need to acknowledge that none of us are perfect, that sure, some of us are better at professionalism and civility, but we all have our problems, we all have a bad day, we all have a particular situation where we might not live up to the standards that the rest of the community wants us to, or that we want to live for ourselves. So it's always good to talk about it, no matter how good we are at it or not. A little bit of backdrop. We don't practice law in a vacuum, obviously. Things are going Things are going on around us, outside of the legal community, outside the practice of law, and everything is relative. All professionalism and civility, it's all relative to what's going on around us. So in order for us to judge what's going on and how well we're doing, we have to sort of look around us. And it's been touched on, especially with Dean Cole. Thank you very much for that little background leading into what I want to talk about, and that is the general tone of politics these days. It is so easy to turn on the news or to open a newspaper, whoever does that, read a headline on the internet about the loss of civility in today's political discourse and among politicians. And we don't need to read the headlines. We can actually see them going at it, see what they're saying, see the names that they're using and calling other people. It's very easy. And I think it's easy for us to get into a sense of despair about that tone, about how that has come about, and including on college campuses, unfortunately, where that always seemed to be a refuge in the past, but it's pouring over. But I don't want us to be too despaired, or I don't think we should be hopeless about that situation. It's happened throughout American history. We just don't remember it. We just are living in today's world, and that's all we can think about. But it's been around for a long time. I think lawyers and politicians get lumped together sometimes because many politicians are lawyers, and we both deal with law. So I think the general public thinks of us in sort of the same vein sometimes. But the good news is the sky is not falling. Things were worse in previous times. In the late 1700s, when this country was just a newborn, we found our independence and we didn't know what to do shortly thereafter. Wow, we won, we got it. Now what do we do? Well, there was lots of different groups, mainly two groups, who really had different, completely opposite of ideas of what this country should look like, and it was vicious. It was terribly vicious. It was no better than the tone that we have now. At the time, they couldn't even agree whether George Washington was good for the country. This Federalist newspaper trumpeted, "Many a private person might make a great president, but will there ever be a president who will make so great a man as George Washington?" At the same time, a different newspaper said this, condemning George Washington: "If ever a nation was debauched by a man, the American nation has been debauched by Washington. Let the history of the federal government instruct mankind that the mask of patriotism may be worn to conceal the foulest designs against the liberty of the people." That was about George Washington. Sounds like something that would be written today about one of our leaders or any of our leaders. This carried on into John Adams' presidency. The public discourse was extremely divisive. He probably had it worse because it had grown worse during his presidency. It got to the point where he and his party supported the Sedition Act. The Sedition Act was so vague that it resulted in what now most of us, most experts, would consider political imprisonment. People were actually put in jail for some of their political discourse that some people considered seditious, when really it was just political points of view. And obviously during the time of slavery and before the Civil War, things got really bad. It was probably the worst of our times in terms of political discourse. None of us can forget the attack on Senator Charles Sumner in 1856 at the hands of Congressman Preston Brooks, who walked into the floor of the Senate and beat Senator Sumner with his cane till near death. It was months before Senator Sumner could return to working. What happened to Congressman Brooks? Well, some things did happen. He was censured, etc. I think he voluntarily left the Congress for a little while. But he was reelected by his constituency, and he went to return to Congress and serve as a congressman after doing that. Not only was his actual act so bad, but his constituents' reaction to that is what is so disturbing to me, that they would actually reelect him. And they praised him for it. It became a point of pride for people to carry canes, because that's what he beat Sumner with. They would carry canes for that purpose. And that is so disturbing. So when we think about today's political discourse, the sky is not falling. We have to have hope that it will get to a better time. And as lawyers, we can help the public get there. They look towards us. If lawyers can be professional and civil, and it's their very job, that's what they get paid to do, to argue, to have differences of opinion, to be advocates. If we can do it in a professional and civil manner, then so can politicians and the general public. We can set that tone. We can set a good example. I am extremely proud to be a lawyer for that reason, that in general, even though we are hired to be advocates and to go at each other's throats, we can, for the most part, do so in a professional and civil manner. If we walked into court on any given day in any given court, you're probably going to find a pleasant exchange of arguments, of legal reasoning and of arguments, despite the fact that we are zealous advocates for our clients. If we can do that, then so can everybody else. And I think that we should take pride in the fact that our profession can do that. What do I think has happened over my course of practice? I've been practicing now 25 years, and I'm happy to say that I think things have been very civil. What I have witnessed, at least in my practice, is a high level of professionalism and civility. And I don't think it's got any worse in the 25 years, despite the fact that in general, the political civility has gone way downhill. I don't think the practice of law has. I think we've maintained a good level of civility. I hope everybody else in different areas of practice sees that as well, and I hope the judges are seeing that for the lawyers who are trying cases in front of them. How do we keep that up? Obviously, we need to keep doing what we're doing and talking about it, and having seminars, and promoting the idea of professionalism and civility. I hope law schools continue to teach it, to promote it. I was so glad to hear that, that Notre Dame continues to have a value-based education. That's where it starts. Well, it starts when we're all little kids and our parents raise us, right? That's really where it starts. But from a professional standpoint, professional training and experience, it starts in law school. And I think Valparaiso was great at teaching us professionalism and civility. They did it so well they're not even open anymore. But I really was very proud when I left there to say that it was, that they did stress that in all parts of their education throughout my time there, from year 1 to year 3. I think it's important to continue to put judges on the bench who promote civility and who set a good example. I think we have a great judiciary. I look up here and I see many of them who set a good example for our litigants, for our practicing lawyers, and we need to continue that in the selection of our judges. I know the selection has changed for Superior at St. Joseph County, and I hope they continue to look at temperament and demeanor when they're choosing their judges, so we can have a high level of professionalism and civility. One thing that does concern me a little bit, that is the effect of television and the public's access to what we do in the courtroom. There's lots of advantages. I'm not going to say it's a bad thing, but more and more every day, the public can see what's happening in our courts. They can see litigants, they can see arguments going on, they can see trials, which I think for a lot of reasons is a good thing. But as Judge Bob Miller said, there is a look at me syndrome. And I'm afraid some people will take advantage of that, knowing the public is watching them, and use that look at me syndrome to promote themselves. Because the general public does sometimes buy into that real jerk of a lawyer will fight for me, therefore he's a good lawyer. Unfortunately, some people want lawyers like that, and what I always say to people who ask about that, I always say, well, there's only one person who likes a real jerk of a lawyer, that's their client. opposing counsel doesn't like it, and that matters, believe it or not. Well, why should I care that opposing counsel doesn't like my lawyer? Well, it's hard to explain, but it does matter. And judges don't like lawyers who are jerks, unprofessional, uncivil lawyers. Jurors don't like lawyers who are unprofessional and uncivil. But some people think that gets them clients, and I don't want that to spill over in the age of access to what we're doing in the courtroom. And I guess that goes back to making sure that our wonderful judges maintain levels of professionalism and civility. So what would I say to young lawyers on this topic? And I know we technically only have one here. I'm not going to pick on you. I know this is being recorded, so maybe there will be other young lawyers watching this. My first thought is you catch more flies with honey than with vinegar. That's an old saying, and it still holds true. But there's not many lawyers. It's the type of people that we are that become lawyers, that we don't just want to be honey, we want to be vinegar. Okay? So I guess my advice to them would be maybe find a good balance. And I, for some reason, always go back to food. I could do everything in analogizing to food, but one of my favorite condiments is literally sweetened rice vinegar. It's like sushi rice. It's vinegar, and you add sugar to it, it becomes sweetened vinegar. So you don't have to be honey. You don't have to be vinegar. Maybe you can be sweetened vinegar. Do it at the right time. Be sweet at times, be honey at times, be vinegar at times, but find the right time and the right circumstance. If you find the right balance, that will make you a good lawyer. The other thing that comes to mind when I think about what I would tell young lawyers is I think about the billboards I'm seeing more and more of with the hammer. I'm not sure if you folks have seen this, but it's unfortunately a personal injury lawyer advertising himself as the hammer with a big picture of hammer. So my message first to new lawyers would be, don't fashion yourself after a tool. Have higher aspirations than that. But certainly the hammer is, has that connotation of hardened steel, and you just go through and you bust everything up. And, that's what clients want. They want a lawyer just going around and bust everything up with a hammer. So don't strive for that. And I don't know the attorney who places those ads. I'm sure he's a great attorney. I'm not disparaging by any means. I have no idea. It's just his choice of advertising. But when I see that ad, the first traits that come to mind are not professionalism and civility. Okay. My wife was a teacher for a long time, and part of the time she was a middle school teacher. And her colleagues always called her the Velvet Hammer. Because she had great classroom control and great discipline without ever having to yell or without ever having a heavy hand. So they called her the Velvet Hammer. So my message to new lawyers would, don't worry about being a hammer, you can be a velvet hammer. And I always wonder, maybe if those ads were back in the 1850s, whether that would be the cane. So thank you very much for allowing me to be here. It's great to see everybody.
I loved Bill Stanley, and it is a huge honor for me to have this opportunity to talk to everyone, even though I am now a retired granny nanny, and had to kind of think back in order to prepare. And the reality is, probably all of us on the panel, I have the most parochial legal experience. I practiced only in St. Joseph County. I never went out of county. The bulk of my practice was in criminal law. So I was a deputy prosecuting attorney, and I tried cases against a pretty limited number of lawyers, several of whom I see in here today. And then I was on the bench in the criminal division. So, after first telling my husband he couldn't say anything about criminal cases, which he obviously violated, I decided, well, okay, I'm gonna look on the internet. And it started okay with, you know, I was reading articles, but some of them were pretty boring. And so I thought it'd be easier, I'll look on YouTube. There are a plethora of cases on YouTube of lawyers behaving badly. Many of them are in depositions where the lawyers start swearing at each other, calling each other's names, and fighting over documents, or taking documents away, or just engaging in enormous bad behavior. So I thought, well, really, I don't know anything about depositions anyway, so I'll go on to trials. I watched a little of the Alex Jones defamation trial. I watched some of Amber Heard and Johnny Depp, and some of the Parkland school shooting case trials. And my first reaction was, oh my God, who raised these people? And then after that was, who would think that this was an effective way to practice law? And I started looking at the comments along these videos, and it became quite clear to me that most of the people that were watching the videos didn't think that this was a way to practice law. And certainly, to the extent that in these depositions, I was looking at the witness that was being deposed, they didn't think this was the way to practice law. So how do we get here, where people would behave so badly? Well, in the reading that I did, they came up with a lot of reasons why we have become less civil in the practice of law. Frequently, it was suggested that a big part of the problem is just there's an increase in the number of lawyers. And certainly that's true in our bar. There are probably half the bar I don't even know. The media has been blamed, not only in terms of publishing this coarsening discourse that's going on in the country, but also on the lawyer shows. You know, even Jack McCoy does things that aren't very that civil, and that could be a reason as well. But so then I started kind of thinking, well, what can we do to make this better? My experience, like everyone else on the panel, is that this is a wonderful bar, and it was a pleasure for me to practice, I don't know if I'd say against, practice with so many of the lawyers here, and to be on the bench with a number of the judges. But clearly there is at least a perception of a problem. And clearly there are lawyers that do behave badly. I've seen a few, but again, not many. I thought, as I prepared for this, that maybe we were going to be dealing with a younger demographic. And it kind of prepared this with the idea of talking to younger lawyers, but and so I'll talk to all of us about all of us old guys and what we could do. It seems to me that, to begin with, the court sets the tone. Bob is right, Judge Miller is right, when he says, there are very few continuing judicial education courses that are geared toward judges being civil. And I know in my own practice, my own time on the bench, that while I took some pride in treating every litigant in front of me, every defendant in front of me, with dignity and respect, I don't think always extend that to the attorneys, especially if I were under stress. We had to get this case moving. If I felt the lawyer was not doing the job that I would have done had I been on the bench, had I been in the well. And I think that as judges, we need to look at our own behavior, because bad behavior begets bad behavior. And we set the tone. Most of you remember Judge Means. For those of you who do not, Judge Means was a wonderful man, the ultimate gentleman, and he was a pleasure for the lawyer to try a case in front of. And he didn't interfere, yet when an issue arose upon which he had to rule, he ruled certainly, and could not be persuaded to change his mind by people whining at him about that ruling. And I remember, they told us we could do war stories, and I was trying to think of war stories, and what I discovered is I remember 1/10 of things. So every story that I have, and there are just a couple, it begins with, I can't remember exactly, but I remember this trial I had in front of Judge Means. And the lawyer who was on the other side, it's not dead, so I'll say his name, Joe Rubin. And it was a terrible case that we were trying. It was a child molesting case, 2 victims, young prepubescent boys. They'd been abducted from their home. The defendant knew the kids, and he got them out of their home. He took them to his apartment. He anally raped them, and then took them away and dropped them off somewhere. We had more than just the word of the children. They had talked about Neosporin having been used as a lubricant, and a search warrant was executed, and they found the Neosporin, and they found the axe handle that he had threatened them with. And so I was in charge of charging the case, and I did include a lot of counts. Every count that I could, that was justified, I charged. And I charged a habitual as well. And I think, from Joe's perspective, I had overcharged, or at least laid it on. And also, I think that he carried the weight with him of the fact that if this guy were convicted, and the evidence was pretty strong, that he would go away to prison probably for the rest of his life. And we were taking a break. It was like a lunch break or maybe a mid-morning break. And the jury had been sent back into the jury room. And we were talking about basically housekeeping matters. And this is the part I don't remember. I don't remember exactly what Joe said, but it was some sort of what appeared to be a slur on my integrity. And I threw something at the table, and Judge Means says, "Now, Mrs. Miller, I'm sure Mr. Rubin did not mean anything by that." And the effect of Judge Means saying that was strong. Because here, what I took from what he said was, one, he wouldn't tolerate it, any uncivil behavior in his courtroom, and that he expected that Joe and I, for the rest of the trial, would behave, and we did. If every judge could remember during the course of the trial the impact of what he is doing on the lawyer in front of him, and often these are young lawyers in front of him, I think that would contribute to civility in the courtroom. I also think that it's important that we have a culture of civility. I've clerked for May Oberfeld, whatever they're called now, when I was in law school. And I remember Bob Knopa took me to something, yeah, a pretrial conference, I guess, in some other county east of here. I can't remember even what county it was. But what I remember, he was unhappy about something that had happened. And what I remember is him saying, we're not like that in St. Joseph County. We could trust one another's word. We don't behave like that. And that meant a lot to me over the years. And I think that if we adopt that culture of civility and pass that culture on to younger lawyers, we will continue to be not like those other counties and do well. The other thing that I think that we need to do is, as lawyers, be really mindful of those things that stress us out. I've always felt, well, that for defense attorneys, especially in very, very serious cases, they carry with them into the courtroom, you know, a heavy burden of responsibility for the freedom and the liberty of the person whom they're representing. And I think that that added stress can sometimes lead to bad behavior. Sometimes the behavior is so bad that it's palpable to the jury. And I am absolutely certain, given the seriousness with which our bar, our defense bar, takes its responsibility, that there's no attorney that wants to behave in such a way that, as one juror explained to me at the end of a murder trial, the jury had to put aside and work really hard to put aside their negative feelings toward the lawyer and focus solely on the evidence and parse out the evidence from the lawyer who presented it in order to arrive at a decision in the case. So we have to be mindful of the kinds of situations that we're in, and we also, I think, have to be mindful of who we are and what gets us going, and work very hard to be the lawyers that we wanted to be when we went to law school. I don't think anyone ever went to law school thinking, I want to be an asshole when I go. So remember the younger you. And the other thing that I think that might be helpful is if we go back to more mentoring. When I started practicing, there was the lawyer table at the PIC, which doesn't exist, which is now the Loft. And was it every day, Bob? Mm-hmm. There was this big, long table in this restaurant, and any lawyer that wanted to go could just drop in. And I mean, I met a lot of real old guy lawyers when I was younger by just going there. And then there was Mark's Restaurant, where, again, they had an open lawyer table. Tom's Restaurant, where I think Mike Barnes and Jim Corporal might have spent a lot of time over the years. And Jim was always a chief public defender, and Mike was the prosecutor, and yet everything went well. I think if we can do more, I know it's hard. I've never been really great about going to bar association things at night. You know, we're busy, we have families. But I think that, this is easy to say at this point in my life, but I think that that's really important. You know, if we love our profession, it's important that we transmit to the younger people who apparently think, some of whom apparently think that the goal of a lawyer is to be antagonistic to everyone around them. But if we can transmit that, Maybe that's our legacy to the law. I want to close with a quote from Don Lundberg. If you recall, he used to be the disciplinary guy in Indiana. And he said, civility is a part of the culture of law practice, is defined lawyer by lawyer, act by act. Everything we do as lawyers either adds to a culture that fosters civility or detracts from it. So I think if we just think as we move forward in our careers, we will add to civility and not detract from it. Thank you.
Thank you so much to our panelists. I think we had so many great perspectives, so many great thought-provoking ideas on civility and the practice of law today. Does anyone have any questions? New lawyer that we picked on numerous times today, do you have any questions? Wonderful, that poor guy. Yes?
I guess this would be primarily for Judge Miller, but you talked about especially emotions not disparaging or the opposing counsel. How would you suggest handling a situation where the opposing counsel in their brief, in your opinion, is misrepresenting the evidence or misrepresenting other case law, where you do feel it is your duty to point it out to the court? How do you suggest handling that in a way?
That's harder, but it's not gratuitous. It's the gratuitous one that bothered me most. I don't know, if you really want to avoid what the circuit standards say, I suppose you could say that the other party's brief mischaracterizes this deposition or is contradicted by this affidavit. Talk about the brief rather than the lawyer. It's a fine line. That might, again, that's if you just look at the standard. But it's not gratuitous. It's the gratuitous shot that is the one that I tend to skip over.
Thank you.
Dean, when I was at Notre Dame, they had a class on ethics. Do you still have that class there?
It's a required class, yeah.
And are there other classes on professionalism and civility?
So there's generally just the one class on ethics and professional responsibility, but there are ethics and professional responsibility components that are built into a lot of the courses. So I teach first year contract, and I spend in a 14-week course, I probably spend a week on the ethics of lawyering and the ABA model rules and the ways in which lawyers can fall into trouble with regard to ethical violations.
And from your experience at Stanford and what you know about other law schools, is that unique to Notre Dame or do other schools?
It's not unique to Notre Dame. All law schools teach a course in professional responsibility and ethics.
Any other questions for our panel? Well, thank you to our panel. Thank you to Tom. Thank you to Amy and everyone for attending today. Are you coming up?
I just have a closing comment.
Perfect.
Again, thank you to the panel. Thank you to you folks that have attended. This is a program that I think is extremely worthwhile and hopefully will continue. We certainly have the funding to continue. I'd invite you on the back of the program. There are 3 quotes that we've used previously talking about civility. I'm not going to read them all. One was by President George Washington. One is by sitting Justice of the United States Supreme Court. But the one that's my favorite is the last one. Make your mama proud. If we all approach the practice of law and how we act as individuals inside and outside the courtroom, thinking how we were raised, as somebody mentioned, I think it was Judge Miller, Jane Miller, We were raised differently than sometimes we see exhibited in the courtroom. Make your mama proud. Take that with you. I invite you to join us. Cafe Navarre is catering a very nice reception. There's an open bar, if any of you are so inclined. And again, thank you for being here.